Hello everyone, I'm Aratrika Bhaumek and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, it would mean a lot to us if you could please like and subscribe to our YouTube channel. Let's begin. The Supreme Court of India today dismissed a petition which sought for details of the Supreme Court Collegium's meeting of December 12, 2018 under the Right to Information Act, observing that the discussion cannot be disclosed to the public and that only the final decision of the Collegium needs to be uploaded on the website. The Supreme Court observed that only the final resolution can be considered as the decision, and whatever is discussed is not required to be in the public domain, that too under the RTI Act. The petitioner, RT activist Anjali Bhardwaj, had placed reliance on the interviews given by one of the judges who was a party to the December 2018 meeting, that is Justice Madan Lokur, that the decision to recommend the elevation to 2 High Court Chief Justices was finalized in the said meeting and that the said decision was changed after his retirement. The Supreme Court of India has underscored that the delay caused by the central government in approving the Supreme Court Collegium recommendations is discouraging good lawyers from giving consent for judgeship. The Attorney General for India, R. Venkataramani, yesterday submitted a status report before the Supreme Court which stated that the High Courts are not making the recommendations 6 months in advance of the vacancy, which is resulting in the piling up of vacancies. Addressing this concern, the Supreme Court bench comprising Justices Sanjay Kishan Kaul, A.S. Oka and Justice Vikram Nath explained the reasons for the inability of the High Courts to make such advanced recommendations. We made a detailed video on this particular order, the link to which has been given in the description box below. Please do check it out. The Supreme Court of India has clarified that the observations made by the Delhi High Court against Sharjil Imam in the order denying bail to Umar Khalid in the Delhi riots conspiracy case will not prejudice Imam's case. A Supreme Court bench comprising Justices Sanjay Kishan Kaul and A.S. Oka was considering a special leave petition filed by Imams seeking to expunge the remarks in the order passed by a division bench of the Delhi High Court on October 18th, denying bail to Umar Khalid. A division bench of the Supreme Court of India has come down heavily on a petitioner who sought damages of Rs 75 lakhs from Google India because he was allegedly distracted by the sexual content and advertisements on the Google-owned streaming platform YouTube and consequently was unable to pass a Madhya Pradesh police recruitment examination. Invoking Article 19, Clause 2 of the Constitution of India, which outlines the reasonable restrictions on the freedom of speech and expression, the petition in this case also sought a blanket ban on nudity on social media platforms. The bench comprising Justices Sanjay Kishan Kaul and Abhay S. Oka expressed its shock and disbelief and said that this is one of the most atrocious petitions ever filed under Article 32 of the Constitution. While pronouncing the order, Justice Kaul also categorically stated that if the petitioner did not like an advertisement, he should not watch it. A division bench of the Supreme Court of India comprising Justices K.M. Joseph and B.V. Nagarathna adjourned the SLP filed in the case of Federation of Retail Traders Welfare Association versus State of Maharashtra today. The special leave petition has been filed challenging the judgment of the Bombay High Court, which has upheld the validity of Rule 35 of the Maharashtra Shops and Establishment Act, which mandates signboards to be in Marathi language in Devanagari script on top and having the same font size as any other language. The Supreme Court of India today sternly directed the Union Public Service Commission, that is the UPSC, to take a final decision with respect to the appointment of Director General of Police Nagaland on or before 19th December. The Supreme Court rejected an application filed by the UPSC seeking an additional 60 days to take the final decision. The UPSC had sought additional time for convening the empanelment committee meeting for preparing a panel of officers for the appointment to the post of DGP Nagaland on the ground that the consultation with the Union Ministry of Home Affairs is currently under process. Disappointed that the fresh appointment is being stalled, a bench comprising CGI D.Y. Chandrachud and Justice P.S. Narasimha noted that UPSC is duty-bound to enforce the order of the Supreme Court. Justice Sanjay Kishan Kaul, the senior-most judge of the Supreme Court of India, after the Chief Justice today, disapproved of the practice of filing lengthy bail applications and arguing as if a final conviction has already taken place. Justice Kaul remarked, and I quote here, "Speaking for myself, I find it a complete waste of time of this court or any court to deal with bail applications that go on for pages and pages. The whole argument is made as if the final conviction has taken place." These particular observations were made by the Supreme Court judge while hearing the application filed by Delhi riots accused Sharjil Imam. In the order passed in the contempt petition filed against the central government over delay in finalizing judicial appointments, the Supreme Court of India has recorded its concern regarding the centre splitting up Collegium recommendations. The Supreme Court has asked the centre to address the issue as the seniority intended by the Collegium gets disrupted when the centre decides to pick up some names, leaving out other names forwarded in the same resolution. During the hearing of the case yesterday, Justice Kaul had orally remarked that some names are approved fast while some others are kept pending for months. Expressing sympathy with the plight of various Indian medical students who could not complete their clinical training in foreign countries like China, Ukraine, etc. due to conditions like COVID and the war, the Supreme Court today asked the Union government as well as the National Medical Commission to find out an effective solution. The court asked the government to constitute a committee of experts to find out solutions for the students' situations, considering the fact that these students can be a national asset when the country is facing a dearth of doctors. A Supreme Court bench comprising Justices B.R. Gavai and Vikram Nath was considering a batch of petitions which were filed by the students when they were in their penultimate years. A court in Gujarat's Ahmedabad district yesterday granted bail to Trinamool Congress, that is TMC spokesperson Saket Gokhale, in connection with an FIR against him for allegedly endorsing a fake news report on Twitter pertaining to Prime Minister Narendra Modi's visit to Morbi last month at the site of the bridge collapse which killed 135 persons. However, he was soon arrested again in a fresh FIR filed against him in Morbi on similar allegations under Section 125 of the IPC, that is promoting enmity between classes during the elections. This fresh case against him has been registered on similar allegations, accusing him of tweeting a fake report claiming that as per an RTI reply, Prime Minister Narendra Modi's visit to Morbi in October this year after the bridge collapse incident had incurred a cost of nearly rupees 30 crores. The Delhi High Court has asked the National Company Law Appellate Tribunal, that is NCLAT, to consider the prevalent position with regards to e-filing of documents across courts and tribunals in the country while disposing of a petition which sought quashing of the order that requires physical filing of documents before the tribunal for the purpose of computation of limitation. The Delhi High Court was told today by WhatsApp that it cannot stop the circulation of a video showing a judicial officer in a compromising position on the messaging app without being provided the phone numbers of the users. They're expecting us to do something that we are not in a position to do, submitted senior advocate Kapil Sibal, who appeared on behalf of WhatsApp. This particular submission was made during the hearing of a suit seeking takedown of the videos circulating on various social media platforms and messaging apps like WhatsApp. The court last month had directed the centre as well as social media platforms to ensure that all appropriate steps are taken to prevent the sharing of the sexually explicit video on the internet. Thank you. Keep watching Courts Today on LiveLaw for more such updates.